Good morning. Welcome to LawNewz Network. I'm Heather Hansen, and we have quite a day for you today. First of all, we want to let you know, for those of us who did not stay tuned in until later last night, John Valerio, the verdict did come back on that death penalty case. As you know, he had already been found guilty of murder, and this jury was meant to determine whether or not he would get the death penalty, life without parole, or life with the possibility of parole. That jury came back later in the day yesterday, and they gave him life without parole. So we did get a verdict in the John Valerio case later in the day yesterday after some bit of time, and that case has now been complete. However, we do want to talk about some of the things that came up in that case, namely the fact that they had an interpreter there in the courtroom the entire trial to interpret for one of the jurors. My guest and I this morning are going to talk a little bit about that and the role interpreters play in our jury system. So stay tuned for that. We also have a phenomenal new case starting for us sometime either late today or tomorrow. This is the trial against Adrian Loya. He is accused of murder for killing his victim, Lisa Trebekova. He also wounded her wife, Ann Trebekova, and a police officer, Officer Jared McDonald. Adrian Loya and the victim had worked together in the Coast Guard in Alaska. Adrian then became obsessed, apparently, with the victim and came to her home on Cape Cod and had a very serious attack that apparently the details that we're going to be hearing through the course of this trial are quite gruesome. The defense in that case is an insanity defense. We're going to talk a little bit about the insanity defense in general and Massachusetts law. This case is being tried in Massachusetts, and Massachusetts is a little bit different than the other states as far as how it handles the insanity defense. So my guest and I will be talking about that case this morning as we await opening statements in that case later on today or tomorrow morning. We're also going to be talking about the hurricane, and namely the statements by Mayor Sylvester Turner, about the fact that he would represent any immigrants if they were to be prosecuted or to be deported for once being caught as part of leaving the hurricane area. So we're going to talk about the specifics of his statement and whether or not he actually could represent those immigrants if they were to be subject to deportation because they actually left their homes and were stopped by the Border Patrol and or ICE. So we're going to be talking about that this morning with my guest as well. And then finally, we're going to be going through some of the greatest hits of the Hernandez case. I know that's one of the cases that you all loved and enjoyed watching, and specifically Alexander Bradley's testimony was especially interesting. Cross-examination by Baez is always fun to watch. So as we wait for the Loya case to start, we'll be looking a little bit at Hernandez today as well. So a full day. And my guest today is one who can definitely handle a full day. Jonna Spilbor is with us. I'm so happy to have you here today, Jonna.
Always good to be with you.
Let's start with the case that we have coming up, because I'm a little bit obsessed with this case because it's in Cape Cod and my parents live in Cape Cod and I grew up going there. And it's a really tragic case where this woman who was a member of the Coast Guard, well-respected, well-liked, her name was Lisa Trebekova.
Say that 10 times.
That is her on the left-hand side. The brunette is Lisa Trebekova on your picture. She is the victim. She was killed by Adrian Loya. The other woman that you see there on your screen is her wife. Her wife took her name, so that's Ann Trebekova. She was injured but not killed. I would expect, I think you probably agree, Jonna, that the wife would testify at this trial.
Oh, sure.
Right.
Yeah, absolutely.
And that testimony is going to be, I'm sure, compelling as can be.
Yeah, well, don't you think this whole case is a little bit strange, especially when you try to get inside his head and figure out what was motivating him to really go crazy.
Right.
Was he crazy?
Right.
When he killed this woman, was there some sort of romantic tension? What was their relationship prior to all this happening? I think that's going to play a big part.
I completely agree. The attorney for Adrian Loya has indicated, first of all, that he's going to be going after the insanity defense. And second of all, that he doesn't plan to do a large amount of cross-examination of the prosecution's witnesses. So I don't think he's going to argue the facts, the fact that his client murdered her, but rather rely upon the experts to say he was insane. Now, the insanity defense is different in different states. And in Massachusetts, there's a couple things that are different. First of all, the standard is that he had to be either substantially unable to appreciate the wrongfulness of his act, or substantially unable to conform his actions to the law.
Right.
What does that mean?
Well, first of all, I don't like that definition, but to break it down, what it means, if you can't conform your actions to the law, we find that a lot with psychopaths, people who are not legally insane, but they just can't control themselves. So that I don't like. And the other prong of that is basically, it boils down to, doesn't know the difference between right and wrong.
Right.
Now, when it comes to the insanity defense, my humble opinion, I think the insanity defense is like unicorns, because it really doesn't exist anymore. It's very difficult. The last case I remember that we had a successful insanity defense is, do you remember Andrea Yates?
Oh, of course.
I think I'm going back over a decade maybe. Killed her 5 children.
Right.
That was a successful insanity defense. But more often than not, it's not successful.
Well, and the reason that more often than not it's not successful is after John Hinckley Jr.'s case, where he tried to kill our president and was found not guilty by reason of insanity. After that case with John Hinckley, a lot of the states changed their laws because they felt that the insanity defense was too lenient.
Too easy.
So in federal court now, the defense has the burden to prove insanity, and the majority of states follow that burden.
Right.
However, Massachusetts does not. So the prosecutor here has to prove that Loya was sane. How much does that change his likelihood of getting an insanity defense to work?
I would have to measure that by saying it's going to be easier to have a successful insanity defense, even though I don't think it's easy at all. But it's going to be easier when the burden is on the prosecution. Just like when you don't have an insanity defense, right? The prosecution has the burden of proving your guilt beyond a reasonable doubt, which means oftentimes when you're defending a criminal, you don't have to say anything, you don't have to do anything, you don't have to present a witness, present a fact, you have to do nothing.
Right.
You could sit there through the entire trial, and if they don't meet their burden, you could be guilty as all get out, but it's not going to matter because technically a jury cannot find you guilty if they haven't met the burden. Apply that now to the insanity defense. I think it's going to be the same analysis.
And it's interesting that you bring that up because just recently, I think in the past year, the Massachusetts Supreme Court has ruled that it is okay if the prosecution doesn't even call an expert in an insanity case.
How is that possible?
Right, if they have the burden, you would. So it seems as though they're slowly inching over to a less liberal standard. What that court said is that if your ultimately what they said is if your cross-examination is strong enough, if you really kill the expert on cross-exam, then you've met your burden as the prosecutor and you don't need to actually call a witness to meet your burden. So that's starting to move into the idea that the prosecutor doesn't necessarily have to call witnesses in order to meet their burden.
You know what's interesting about that? I think it speaks to the fact that most people hate the insanity.
That's right.
We don't like
That's
it.
right.
If somebody, because, you know, think about it. If somebody does something brutal, like in this case, for example, right? You brutally murder somebody, all the jurors are going to have a hard time allowing someone to potentially go free based on that. Because look what happens if you are found not guilty by reason of insanity.
Right.
You go to an institution, you allegedly get better,
Right.
and then if you're competent and healthy, you're back out with the rest of us.
Well, and that's problematic. The other thing that I think is going to be interesting in this case, and we've talked about this, I know we talked about it with the War Machine case, and I think we've talked about it with some others, where now we have brain MRIs and brain CTs and all of these different studies that may show changes to a defendant's brain that would support an insanity defense. So I'm really eager to know whether or not this defense attorney has had these types of studies performed on his client to use them as a support here.
Interesting. Does the client have a background? Because when you said that, immediately I went to O.J. Simpson. You know, O.J. Simpson, football player, lots of blows to the head.
Chronic traumatic encephalopathy is a big thing these days.
And I will never be able to pronounce that. But, you know, he was found not guilty, not by insanity, just because the juror let him go. But I wonder if that could have played into, assuming he did it, and most people believe he did, if that could have played into it.
Yeah, and I think that we're going to see that more and more. The science behind these brain studies is fascinating, and it certainly would be helpful because I think you're right. I think most jurors don't want to find insanity.
No.
It's something that's hard to understand. It can be faked, at least some people feel,
Right.
and they don't want someone to be going free. But you can't fake a brain MRI. You can't fake a CT. So if I was defending someone with an insanity defense, I would want to do my best to find some objective medical studies to support that defense.
Yeah, and I think that would be your strongest defense. And if I'm in the jury box and you show me evidence that this insanity was come by honestly, meaning a bunch of blows to the head, a traumatic brain injury, something, that might sway me to find insanity where I otherwise would not have.
Right, and in the meantime, we're seeing the victims. I mean, these two beautiful women, and the reports, if you read newspaper reports about this case, the reports about the victim, Lisa Trebekova, and what a wonderful member of her Coast Guard group that she was, how well she was respected by them, how much they all loved her, and they said they would like to have thousands of her working there. I mean, it's really a tragedy, and it's a tragedy for that community. That police officer was shot in the spine. I'm not clear, but I think he's still in rehabilitation for that, and he's no longer acting as a police officer. So it is a big case. It is a tragic case. They weren't able to get a full jury yesterday, so they're continuing with jury selection. And let's talk about that a little bit. Do you think it's harder to get a jury when your defense is an insanity defense?
Well, it definitely is probably the prime factor that you're going to have to screen jurors for, because if you're not open to somebody who would accept the insanity defense, obviously you got to go. Similar to if you're selecting a jury in a death penalty case, right? If you're on the other side of this, if you're a prosecutor, you have to get people who would vote for death, right? So there are two extremes there. But yeah, I think and jurors are such a strange breed, because we put a lot of pressure on juries, especially in these big cases where they're death penalty, insanity defenses. It's a lot of pressure. And most jurors don't have a legal or medical background. You might get lucky and find one if you want to keep them on the juror. But it's, I always picture, like, if my mother was on an insanity defense jury, there's no way. She's got that guy guilty before the first, I just got her out of jury duty for the rest of her life. But, but people have that mentality, and you're getting that cross-section of society. It's really difficult.
Well, and I think it's hard. I think it's harder to get a jury who can say, because you're going to have a lot of jurors like your mom who are like, no way, I'm going to go for this insanity defense stuff. That's not going to happen. And I think you're right. I think a lot of these issues for jurors can be overwhelming. I know in jury selection, a lot of times, especially when I have medical cases, people are like, I don't understand these medical terms, and I don't know anything about medicine. And ultimately, I always tell them, and in my openings, I often say, all you have to do is use your common sense. Bring this back to common sense level. But it can be overwhelming. And the common sense of most people, I think, tends to lean on the opposite side of finding for insanity.
Yeah, and I would agree with that. And let's add one other thing, and I am not being critical of jurors in this, but if you don't have a head for, let's say you're on a medical malpractice jury, right?
Right.
But you don't have, you're not a doctor.
Sure. You
could end up falling asleep during some of that expert testimony.
No doubt about it.
When I have to
all the time.
read reports, I'm like, and you have to remember that, because those people are in charge of what's going to happen to your case and your client.
Absolutely. And as an attorney, it's your job to keep it lively and keep it real and keep it to the common sense. And in a case like this, which is so very tragic, I do believe that the jury here, as chosen, will be able to listen to all the evidence and hear it fairly. They expect this case to last about a week. I do think we'll hear a lot of medical experts. There was some going back and forth with the lawyers and some motion practice earlier about recording the various experts' meetings with the defendant. So apparently the defendant met with the psychiatrist or psychologist for the defense for a period of days, and that was not recorded. And yet the defense attorney wanted the meeting with the prosecutor's expert to be recorded. So we'll see how all of that plays out during the trial.
I'm a little surprised, because it's going to take a week to go through. Didn't he write a 250-page manifesto before he committed this? That's going to be chock full of information.
Right.
And
absolutely. And how much of that will get in.
Right.
And to your point at the very beginning of this discussion, I get the sense from what I've read that he believed there was some sort of a relationship there between he and the victim. And so I'm sure that will be explored as well. But for this community, I know this community. It's a small community. It's a beach community. And I'm sure that they are
a safe community.
It is a safe community. And they have a lot of respect for their police officers. And you can't forget that a police officer's life was forever changed by this. So Adrian Loya case starting later on today. It's going to be one to watch, and we're going to all enjoy watching that for sure, and seeing how this insanity defense plays out and being able to sort of compare it with some of the other states. The other thing that I wanted to talk to you about this morning is the the mayor last night, in one of the mayors in Texas came out, Mayor Sylvester Turner came out and said that if there were people who were deported or threatened to be deported as a result of having tried to evacuate, and you see pictures there of the flood and all the terrible devastation, that he himself would personally represent them. And he's getting a lot of kudos for that. I don't know if we can see the tweet where they actually quote him as saying that he himself would personally represent them. But he's getting a lot of kudos for having said that he would personally represent them.
Right.
And I actually I applaud the sentiment.
Yeah.
I know, but I was curious when I saw that, and I thought, well, can he personally represent them, because he's the mayor, and who would pay him? And if he's going to do it pro bono, is he taking time away from his job as a mayor? What's the deal with that? Can a mayor represent his constituents against the federal government if they're deported?
I think that screams conflict of interest at the very least, because for what you pointed out, he's got constituents. Who's paying the bill? I mean, I know that he's a licensed lawyer, I guess, and Harvard educated, from what I understand. But no, I think what he's doing is really trying to curry favor with the best of intentions. I get it, you get it, but could he actually represent them? I say no.
Yeah, and the other thing that's sort of challenging about this is that in saying that, I think that many people then thought that these people are risking the chance of deportation. And FEMA actually has on their website, and I don't know if we can pull this up, the rumor that they wanted to address with regards to this. And they wanted to specifically address this rumor because they felt as though it was something that was out there. And the rumor was that, and I can actually pull it up on my sheet here, the rumor was that the U.S. Immigration and Customs Enforcement and U.S. Customs and Border Protection is responding to this rumor and saying that it is not conducting immigration enforcement at relief sites such as shelters or food banks. And then they go on to say, in the rare instance where local law enforcement informs ICE of a serious criminal alien at a relief site that presents a public safety threat, ICE will make a determination on a case-by-case basis about the appropriate enforcement actions. So the bottom line is, for those people who are afraid of leaving their homes, they are able to do so without threat of deportation.
Yeah.
So hopefully the mayor won't have to quit his job and go representing all of these people. But I do think that I can only imagine the stress of being in this situation, and then the added stress of being afraid that if you actually save your own life, that you are risking deportation.
But let me take the other side of that for a second.
I know you would.
And again, I don't want any lives lost in this. I don't care whether you're here legally or not legally. But I think the mayor probably should not have come out and made that statement. What if the mayor had come out and said, on the same side as FEMA, you don't have to worry. Nobody's going to have to represent you because you're not going to be arrested unless you're a hardened criminal.
Okay, so here's the tweet. Here's the mayor. Can you bring that graphic back up, guys? There you go. There's the mayor, and he said, if someone tries to deport you, I will represent you myself. And your point, Jonna, is that rather than saying that, which maybe leads people to think that that's a possibility.
Scare tactic, right.
Right. To instead say, FEMA has said that they're not intending to, neither the Border Patrol nor ICE is intending to deport anyone, and so you can rest assured. But I think, and I don't want to get into a political debate here, but I think that part of the concern is that because of our current administration and their attitude towards immigration, that a lot of people don't trust the federal government necessarily, and they do trust their mayor, who's standing before them, making this statement that he's going to take care of them.
So then the mayor could have just as easily said, I have verified, and you have my word that FEMA is going to keep its word and not deport anybody. Please come, make sure you get help. We don't want anybody to die. He could have sent that message, which might have gone a long way in getting people to trust the federal government. We don't want any. I mean, this is we can't control the weather, and this is a tragedy. But I certainly don't want anybody not getting help for fear that they're going to get deported for that.
Absolutely. So that's a situation that continues to be a problem, and we continue to see so many people donating to Red Cross. And then I know you're an animal lover. I saw a lot about the SPCA.
My heart.
I know.
Heart.
It's going to be a long time to clean up, but I know the people in Houston, in Texas, and in the surrounding areas are tough as nails, and are going to try and make it through. So we'll continue to cover those issues on LawNewz.com. But in the meantime, there's another case that is up on our site. Heather Elvis, she is missing and has been missing for years.
Yeah.
And Sidney Moorer and his wife Tammy have been accused of kidnapping. And Sidney Moorer, was tried for kidnapping. That case ended in a mistrial. But now he has started another trial for obstruction of justice. That is, you're able to access that trial on our website, LawNewz.com. And I don't want to get too much into it, Jonna, but I want to ask you, one of the things that was interesting to me is that they're separate trials. They've got the obstruction of justice trial separate from the kidnapping trial. And in some of the reading that I did, I saw that originally they were put together and then they were separated. In general, when would you want those cases tried separately? When would you want them tried together? Is it better for the defense to have them tried separately? How does that work?
You know, that's interesting. My first thought when I learned that he was going to have a separate obstruction trial was, this is my honest first thought, that law enforcement really wants to stick it to him. Like maybe they feel he's getting away with something, because I also read, and correct me if I'm wrong, originally, he was not just charged with kidnapping. He was also charged with murder, and that charge was dismissed. And I'm only surmising, because they don't have a body, which means, okay, so it's possible in the future that they could charge him with murder should they have more evidence to it, since he's only been charged. I don't think double jeopardy would apply when he's only facing kidnapping and obstruction charges.
Right.
And maybe they want to make sure that whatever happens to him, his sentences run consecutively and not concurrently, to maximize his time in prison so that they can continue to see if they can find a body. All theory, all conjecture, don't know, but that was my thought.
Yeah, and that's a very good thought, because it's not quite clear from the reports that we're having thus far. But you know, the Moorers are an interesting couple. My understanding of the case is that Sidney Moorer had an affair with Heather Elvis, and his wife caught him. And one of the alibis that he gave for the night in question was that his wife had him handcuffed to the bed, because she would handcuff him to the bed.
Why not?
Well, you know what? Once you stray, I guess that having you handcuffed to the bed is the way to make sure that that doesn't happen again.
Right.
So they're quite the characters, and that case is interesting. And as noted, that is available on our website, LawNewz.com. Later on today, we are going to have the case of Adrian Loya, the case against Adrian Loya. But I don't want to forget that yesterday when I left, we were in the middle of closings in the John Valerio case. And since I left, and later on last night, the jury did come back with a verdict. In that case, they had some issues. The whole issue was the death penalty, whether or not John Valerio was going to get the death penalty. And the jury came back and said no death penalty, but also no possibility of parole, which it seemed to be was really what the defense attorneys were looking for. And instead, they found for life without parole. What do you think about that, Jonna?
I think in a case like this, it is a win. Isn't it funny? You know, I've represented criminals for 24 years, and it's when you think of success as making sure your client stays alive but never gets out of the clink, and that's what they're doing here. And so I can appreciate that from a criminal defense attorney's standpoint. What bothers me in a lot of these death penalty cases is if it ends up that way more often than not, why don't we try to resolve them more without having this penalty phase, without having a trial, without using the resources, and just agree to that? Just agree to that.
Well, and I think it's an interesting question, because I'm not sure where the pushback was, whether it was the prosecutor who said, no, we want the death penalty, or whether the defense really wanted the possibility of parole. Because in their closings, they split. Well, first, I want to ask you about this, because I thought it was interesting. The defense attorneys split the closing. What do you think of that as strategy-wise? So one attorney closed for, I'd say, about 20 minutes, and then the other attorney for the defense got up and closed for the remainder of the time. What do you think about that?
Answer this, because I was not able to see the closing.
Yeah, sure.
Did one attorney discuss forensics and the other one discuss the basic trial strategy and facts that came forward?
Well, one discussed the facts, and he was more straightforward and factual, and the other got back and said, this case is about hope, and don't take away his hope by not giving him the possibility of parole. So they kind of, one played the straight man and one pulled at the heartstrings. But I want to talk about pulling at the heartstrings. But before we do that, do you think it's a good strategy to sort of have two different people argue the two different aspects of the defense?
It would completely depend. Like, let's just say I've never done it. that way.
neither.
Now, what I have done and what we see all the time is you could have multiple defense attorneys on a team. One of them does the cross-examination, one of them does direct examination, and you split the duties that way. But usually, there's one person who does openings, and there's the one person who does closing. Typically, it could be the same attorney, but it doesn't have to be. So there would have to be I would really like to talk to those attorneys and find out what was your exact reason for splitting it up. Because you want to appeal to the sentiment of the jury, even though technically you're not supposed to do that, right? You're not supposed to appeal that. Maybe one of the attorneys had to be the heavy during the trial and they wanted to soften it some, and so they got somebody else up there to take that piece of it.
And I got the sense that the defense was really hoping for this possibility of hope. It's what they talked about in their opening, and then they talked about it again in their closing, that by giving him the opportunity to get parole, they would be giving him some hope for the rest of his life. And the prosecutor was like, you know what, that hope may mean that he can walk right out of this place because he's already served 20 years.
Right.
So it's interesting to see what the jury did there. And they said, we're not going to put you to death, but we're also not going to give you the hope that you asked for.
And that's the other thing. I wonder how much that hope theme played into picking those jurors. Because maybe the person who came up and talked about hope is the one who did voir dire for that panel of jurors, and maybe they were connecting those two dots.
One of the I want to talk to you about this at some length because it was fascinating to our team here at LawNewz. There was an interpreter there throughout the entire trial because one of the jurors may have had some issues with the English language. And there's a statute that I'm going to talk about after this next clip that speaks to how much English a juror has to be familiar with. But I want to play a clip of when John Valerio was talking to the jury during his allocution and talk to you about how much English do the jurors have to be able to understand to really understand the testimony, and how much can a translator serve?
Screw that up? Oh.
Well, yeah, and how well can they serve? And when it's not absolutely necessary, do we want that to be the standard? So let's play a clip of John Valerio's allocution testimony. It's not that long, and while you're listening to it, listen to it with the idea of if this is being translated by someone into, and we don't know what language, whether it was Spanish or Chinese or Russian or whatever, but if it was being translated into another language, what tone, what words might lose a little bit of their meaning? And then Jonna and I are going to discuss our own experiences and what role interpreters play in our court system.
Good afternoon, ladies and gentlemen of the jury. I wanted to talk to you first and foremost because I wanted to talk to you and look at you and let you hear my voice. And of course, I also thought that if I was sitting in this chair, I would probably want to hear from me. So for those two reasons, I wanted to speak to you. First and foremost, there's not a day that goes by that I'm not remorseful and that I don't think of Miss Blackwell and the things that happened in 1986. I want you to know that. Let's see here. I didn't write a statement because there were a couple of things I wanted to talk about, so please bear with me. My family, Ms. Blackwell and her family were also affected by this, and I want to apologize to them, Ms. Blackwell's friends, my family and friends who have stood by me throughout my incarceration, and I know it hasn't been easy for them. This has been a lot for a lot of people. The last 31 years, I've heard a lot of talk about how I changed or how I haven't changed. There's been discrepancy about that. I feel that I have, specifically the term mentally, physically, and spiritually. Those three elements are essentially what I've taken in one day at a time. And it starts with mentally. And the reason it starts with mentally because if you're reading spiritual, if you're concerned about being physical and working out and exercising, if you're not mentally intact, the rest they don't go together. So I started with that. I took an assessment of myself and the things I've done the first 21 years of my life when I first got incarcerated. I think it's probably not very difficult to see that I was a menace. I mean, there's no other way to put it. I made a lot of mistakes. I did some things right, but I did a lot of things wrong. Now, the past 31 years, prison does a lot of things for you. It gives you time to take a look at yourself every day in the mirror when you shave, every time you have a conversation with somebody, and you can either do one of two things. You can either change or you can remain the same. A good friend of mine once told me, her mother actually told her this, and it was a really good quote. She said, my mom used to tell me, when you're down on your hands and knees, probably the best thing you can do is pray while you're down there. I did that, and I'm still doing that. I don't run around with a Bible telling everybody how I'm religious or how they need to change their lives, but I do read spiritual material, things that are positive. I made better choices today. And to me, making better choices, things get easier when you make better choices. I mean, rules, various things that I've done throughout my incarceration, they're because of those things. My way of thinking, I try to associate myself with positive people, encouraging people. I try to be encouraging, I try to be positive. And every once in a while I realize that I've made a difference to somebody. I don't do it for self-acknowledgement or a tap on the back, but it does feel good every once in a while when somebody acknowledges that you made a difference for them and to them. I've done that in prison, I've done that with pen friends, I've done that with my parents. They've seen a change in me. I know I've changed, and I haven't changed because I knew this hearing was coming 15 years later. I haven't had a lack of charges for 17 years because I knew that I was going to be in front of you making this statement someday, and, well, I want to convince them, look at what I've done here. That's not why I changed. I changed because I'm being accountable for all of the things that I've done. I've changed it, as I explained. When I was at my lowest, there was only one way out. I had to make changes. There was a good person in there. Was there a good person the first 25 years? As I said, I did a lot of things right, but I also did a lot of things wrong. So, honestly, I also wanted to talk about my plans for the future if at any given time I'm ever given the opportunity for a chance at parole. I'll have to continue to do the things I told you about. Because if I don't, that chance will never take place. But I won't do those things to make it to a parole board to please them. I'm going to continue to do those things just like I've continued to do for the past 31 years when I didn't see that there was a chance at a parole board somewhere down the line. Because that's who I am. It's not a facade, there's nothing fake about that. That's just what I'll continue to do. And I'll do my best not to let anybody down. If that ever happens somewhere down the line, I don't know. That's going to be your decision. Okay, so I think I'm going to wrap this up because for the most part, like I said, I wanted you to hear my voice, see my face, and speak to me. I've been over there for a couple of weeks, just taking notes, and I'm going to wrap it up for now. I'm grateful for your patience and understanding.
So that was John Valerio, Jonna, talking to the jury about his feelings about, he's been rehabilitated, etc. Now, one thing I want to note is I couldn't hear the interpreter. most often
Right.
they have to pause unless the interpreter was sitting right next to the person with the language issue and quietly
my
speaking.
feeling, yeah.
You think that was probably the case?
Yeah, and sometimes they have them like talking to sort of like this cuppy thing, like, yeah. So I think that is, and that's a good thing because you don't want the interpreter to be a distraction
Right.
for the rest of the people who don't need the interpreter.
That's right. So I once had a case where the party on the other side needed an interpreter the whole trial, and so he was interpreting the whole trial for her. And sometimes it was a distraction for me because they were sitting at a table not too far from me, and he's talking throughout the whole thing, and it's just tough luck because she needed to be able to hear all of the testimony as a party.
Yeah, and usually, like I said, I maybe it's more modern now where they can actually speak into something so they're not very ambient, and then the person they're speaking to has an earpiece in like we have, so it goes straight into their brain, so to speak. But I would be hard pressed. I don't think I've ever had a situation where I've selected a jury where somebody would need the assistance of an interpreter was even an option.
Right, me either. Now we looked at Aaron, our one of the co-hosts here, picked up the statute, which says that a juror has to have sufficient knowledge of the English language. That's all that it says, and it doesn't define sufficient knowledge of the English language. So.
What does that mean?
If you're the lawyer on a case like this,
Yes.
would you object to having someone who needed an interpreter on the jury?
I think I would. Oh, but only for the reason, have nothing to do with intelligence or able to understand or anything like that. Because of the potential distraction factor.
Right.
And with so many, I mean, typically you've got a very large pool.
Right.
Why would you have that added element unnecessarily? So maybe this juror was somehow fantastic. And you have to remember, then if the juror needed assistance during the trial, during voir dire, which is where we pick the jurors, same deal, right? Must have been.
And you know what just occurred to me, and I don't know the answer to this question, and I don't know if you do either, but did the interpreter go into the jury deliberation room?
Would have to.
I don't know if that's allowed. But listen, maybe the person had a pretty strong grasp of the English language and they were just acting in an abundance of caution. But no one other than the jury is supposed to be going into the jury deliberation room. But if they need help with the English language,
Right.
you'd think that they would need help during deliberations as well.
They would absolutely, because you discuss things in the deliberation room.
Right.
So, this, I probably shouldn't get too far afield here, and I don't want to make any enemies, but, how is this any different than what if you had a juror who had a low IQ, right? I mean, you can understand English, but can you understand what's going on in the trial?
Well, and the other thing that I think maybe happened here was maybe the interpreter maybe it was sign language.
Oh.
There's a lot of possibilities here, and it does bring up a lot of interesting issues about our court system because the resources, I know for us, I've had interpreters now in a number of cases for witnesses, not for jurors.
Yeah, not for jurors.
And for us, the court system provides the interpreters.
Right.
So that's paid for by taxpayers.
Right.
And in one of my situations, the person who needed the interpretation was Chinese, but her dialect was different than the people that were being provided. And once we had to wait, no exaggeration, a full day for the right person to come and interpret, which then the jurors were getting frustrated with.
Yes.
It can be difficult, and yet these people who are having some challenge with the English language are certainly entitled to be able to understand the proceedings. So it can be a challenge.
And an unnecessary one. Like I said, if you get a pool of many more people than you're ever going to need on a jury. So I wonder what it was about that particular juror that was special, or that, which side wanted to, I guess both sides wanted to keep the person on. But maybe you're right. What if it were a sign language? Then you could go in the jury deliberation room and read lips.
Right.
But maybe you can't see the lips from where you're sitting on the witness stand.
Right, or you could write things down and things written down. Yeah, that's an interesting thing. But 1 in 5 households now don't speak English as the primary language at home. And so we may see this more and more often. And it's something that our system is going to have to allow for, and maybe there's some sort of technology that can help with these situations. I know that some of the clients that I work with have things translated into different languages for different customers or clients. And so there's translation that can be done very quickly, almost in real time. So I do think that this is something we're going to see more and more often in our system and in the court system. And in this particular case, we at LawNewz all thought it was very fascinating that we had it live here in front of us. And maybe we'll get some more details on that as we explore explore a little bit more with that Valerio verdict. But that verdict has come down. The jury found that he would get life without parole, so sort of a compromise verdict between what the prosecutors want, which was the death penalty, what the defense wanted, which was the possibility of parole. So that case is done. The case that we have coming up for you now is this Adrian Loya case. It is going to be a really interesting case. The insanity defense, as much as we talk about it, it is not used all that often, and it is being used in this case. And it's in Massachusetts, where the prosecutor has the burden of proving that the defendant was not insane. And that's a tough burden to overcome. So that case starts later on today. We'll be talking a little bit about that throughout the morning. But what we wanted to do as we wait for that case is to take you back to some of the testimony in the Aaron Hernandez case, because that case really was where we all sort of started following these trials here at LawNewz most heavily. And that case in particular was exceptional in the cross-examination, especially of Alexander Bradley. I know you were on, Jonna, during some of the Aaron Hernandez case.
Yeah.
And Alexander Bradley, you know, this turncoat witness, he really, I mean, we've got days and days of his testimony, and we're going to be playing some of that. But ultimately, he didn't carry the day for the prosecution, did he?
Was he the street sweeper?
No,
Who-
the street sweeper. He was the narc. Well, he was the one who was friends with Aaron Hernandez, and then turned on him and said that Aaron Hernandez had shot him. And we're going to watch a little bit of his testimony to sort of tickle all of our memories as to who Alexander Bradley was and his role in the Aaron Hernandez case, and then talk about whether or not witnesses like this, who are witnesses for the prosecution and maybe getting a deal, how effective they are with juries. So here's some of the Alexander Bradley testimony, and then we'll be back to discuss.
I mean, I recall a couple different scenarios, but one in particular, a gentleman was staring at him.
Where were you? Do you remember which club?
I think we were at Rumor for that particular club.
Rumor in the Theater District of Boston?
Yes. And a gentleman was staring at him, and it turned into, you know, an incident. I believe Mr. Hernandez asked the gentleman what he was looking at, and the gentleman responded by saying, "I'm looking at you." And, you know.
What happened after that?
Somewhat of a conflict ensued. It wound up getting ironed out with the gentleman saying to Mr. Hernandez, you know, "I'm looking at you, you lost me a lot of money on the Super Bowl," type of thing, is what it turned into.
Were any punches thrown?
No.
Did you have to physically get involved in any way?
Yes, I wound up kind of diffusing it. I spoke with that gentleman, and, you know, it kind of turned into nothing after that, but that was the extent of that situation.
And what about any other situations?
There was an incident in Connecticut, I believe I remember, in Waterbury, Connecticut, where same thing happened with a gentleman who was staring at him. And Mr. Hernandez always had a problem with people staring at him.
What would he say, if you recall, when people were staring at him? Did he say something to you?
He usually would say he didn't like people staring at him because he felt like they were trying him or testing him.
And you use the word trying?
Trying was the phrase he usually used.
He would usually use that word?
Yes.
Like in what context?
Mr. Hagan, do not leave.
You said he used a certain phrase in describing when people stared at him. What was that word that he used?
Question asked and answered twice. Overruled.
What would he say?
He said he didn't like when people stared at him. He felt like they were trying him.
Did you have a conversation with him when he would say that at the club, particularly at this time in, I think you said Waterbury?
Well, I don't remember what I said to him at that particular time, but what I usually would say was, you know, you're a famous NFL player. That's what's going to happen. It's not that big of a deal. In other words, I used to try to explain to him that people weren't trying him all the time. It's just the situation, the position he was in, and he didn't really need to overreact all the time to that type of scenario.
Okay. And you got your own interest at heart here, right?
At this point, yes.
Okay. So the police come get you because you don't show up, right?
Correct.
They hold you on a $250,000 cash bond.
I believe it was higher, but it could be right.
Okay. And you start making calls to your family.
I made a call to my daughter's mother, correct?
Okay. Brooke Wilcox.
Correct.
Right? And you talked about some of the statements you made to Brooke yesterday. You mentioned them, right?
I believe they were mentioned, correct, yes.
Okay. Well, let's say exactly what you said. Do you recall saying, I don't know shit about that shit?
Yes,
And you're referring to Boston, right?
correct.
Okay, and then you say, they are just gonna ask me about a bunch of shit that I don't know.
Correct.
You're lying, right?
Yes,
Okay, you're lying, Brooke,
correct.
the mother of your daughter,
Yes,
okay? And then you say, on October 6th, they sound dumb as fuck. How's my testimony crucial?
he wasn't real social. He's kind of standoffish, excluding me, you know. He didn't really mingle too much inside the clubs. He wasn't very social.
Did you have, prior to July of 2012, other than what you've already testified to, did you have conversations with him about him feeling that people were trying him or testing him?
Objection, Judge. Ask and answer.
Sustained.
Calling your attention out, sir, to the Super Bowl in 2011, actually into 2012, the Super Bowl, Patriots versus the Giants. Did you go to that Super Bowl?
Yes,
Where was that?
Indianapolis.
What was the result of the Super Bowl, the game?
The Patriots lost.
Did you notice any difference in the defendant's demeanor after that game?
Not particularly after the game. I mean, I know he was sad that they lost, but
And what about the times that you went to clubs after February of 2012? Did you continue to go to nightclubs after that?
yes, we did.
And what clubs did you go to?
Usually Cure,
Usually,
yes.
were there any other instances prior to July 16th, 2012? Were there any other instances at Cure that you recall of the defendant getting angry?
Particularly, no. No, not that I can recall.
And how frequently would you go? In other words, was it a weekly thing? I'm talking now into 2012, the winter into the spring of 2012. How frequently would you go to nightclubs with the defendant?
Very frequently.
Week? How many times a week?
Well, with him, usually once a week. With him. I mean, it would depend. If the football season was out, it would be times we went 2 times in a weekend, 3 times. It would depend on the schedule.
At some point, Mr. Bradley, did the defendant, Aaron Hernandez, ask you to help him purchase something?
Yes.
What did he ask you to help him purchase?
He asked me to get him a firearm.
Do you know when this was, particularly in relation to July 16th, 2012?
I want to say definitely at least a month prior, maybe 2, but definitely a month prior.
A month or 2 prior?
Yes.
Did he indicate to you why he wanted you to purchase a firearm for him?
Yes, he felt like he needed it for protection. He felt like he was tired of people trying him and, you know, people staring at him. He felt like people thought he was soft or something, and he was out to prove something.
He told you that he felt that people thought he was soft?
Judge, counsel repeating the witness's answers without question.
What a question.
To give the context of what you just stated, Mr. Bradley, what did he say about what he thought people thought of him?
He was fed up with the whole feeling as if people were trying him situation, so he wanted a firearm to protect himself in the event.
Did he ever indicate to you whether or not he felt he was being tested or tried in certain areas as opposed to others, meaning certain cities?
Yes, it was usually in downtown Boston area, Cure area.
He told you that?
Oh, that's when he didn't say, I feel like they, you know, trying me here in Cure, but that's where he was on heightened alert, was in that area all the time.
Objection,
Right. Lay a foundation for that, counsel.
Did you have conversations with him both prior to and after going to clubs in Boston, downtown Boston? Just general conversations?
Yes.
And did he ever indicate to you any stress or angst that he had about going to clubs in Boston?
Yes.
What did he say exactly?
He was tired of feeling like people were trying him. He would ask me, why don't people stare at you like that?
What would you say in response?
And I'll respond to him, Pretty much because I'm not you. I mean, I would say we're not in the same position. You know, you're a star athlete. I'm a regular person.
Now, do you recall, Mr. Bradley, whether or not prior to July of 2012, if Mr. Hernandez had a situation with any particular group of people in Boston?
There was a particular group of people who he felt like, you know, were always staring at him or watching him or type of thing, where he had, you know, eye contact with.
Do you remember anything about that group of people, like any types of shirts they wore or anything like that?
Yeah, it was a group of people. They used to wear these shirts called that said City Angels on them, and there were a large group of people. There usually were a lot of them. There was always a lot of them in the clubs.
Where were they? Were they in particular clubs or
Cure usually.
in Club Cure?
Yes.
Did they wear shirts that said what you've described, City Angels?
Yes.
May I approach a witness, sir?
You may.
All right, the next paragraph reads, sir, based on these representations, the following sets forth the agreement entered into between Suffolk County District Attorney's Office and your client, Mr. Bradley. Do you see that?
Yes.
Okay. This is the agreement that you guys entered into. Mr. Bradley agrees to provide a complete and accurate proffer. Well, let's stop right there for a second. You understand what the word complete means, right?
Yes.
Okay, and you understand what the word accurate means, right?
Yes.
You're aware of the word, of the phrase lying by omission, right?
I'm aware of the word lying.
Okay. Do you know what that means, lying by omission?
No, can you explain it to me, please?
Sure. It means when you tell half the truth, you don't tell the whole truth.
Objection. Now overruled.
You understand?
I understand that.
Kind of like your oath. Swear to tell the truth, the whole truth, and nothing but the truth. You understand?
Correct. Yes, I do.
So complete means everything, right?
Yes.
Okay. And accurate means truthful, right?
Correct.
That's what it means to you too, right?
Correct.
All right. Now, proffer regarding the above described incident. No statements made or other information provided by Mr. Bradley during the proffer will be used by the District Attorney's Office against Mr. Bradley in any judicial proceeding. That basically means to you, right, that whatever you say can't be used against you in any proceeding, except, we're going to get into that. Do you understand that to be correct?
Correct.
All right. Now, except as for the purposes of cross-examination, rebuttal, or impeachment, should Mr. Bradley offer testimony or evidence in any proceeding which is materially different from any statements or information provided during the proffer. Do you know what that means?
Yes.
Okay. It means, let me see if I want to be clear. Does it not mean that if you lie or you say something, they can cross-examine you? They can cross-examine you or rebut what you say.
Correct.
Right?
Yes, that's what I
Okay.
mean.
And then section B says, in a prosecution based on false statements made or false information provided during the proffer. Do you understand what that means, sir?
Yes.
Okay. Does that not mean to you, sir, that if you lie, they can prosecute you for perjury?
Yes.
Okay. Have you been charged with perjury yet, sir?
No, sir.
Okay. This agreement, I'm sorry, in the prosecution for the proffer, this agreement not to use Mr. Bradley's statement against him applies only to those statements made during the course of the proffer, which certain and specific investigation, which pertain to the specific investigation set forth above. You understand those words?
Yes.
Okay. Next, Mr. Bradley agrees to provide complete and truthful information to law enforcement officials investigating the above described incident. You understand what complete and truthful mean, right?
Yes.
Okay. Again, we're using that lying by omission, complete, right? You understand that?
For the fourth time, yes, I understand.
All right. Now, well, we're going to go over some more, so don't worry. Next, truthful. This is different than accurate, but it's the same thing, right?
They don't mean exactly the same thing, but they're close.
Okay, what's the difference between truthful and accurate to you, sir?
Truthful means the truth. And accurate means accurate.
Okay. But in this context, it means something different to you?
Objection.
No, you may explain the difference in your mind between those two terms.
Accurate means, in my opinion, accurate means, precise, almost precise or close to it. Truthful means truthful.
Okay. And truthfully, before any grand jury investigation, the above described incident and any subsequent hearings and trials relating to the same, Mr. Bradley agrees that he will neither withhold any information. You understand what withhold information means, right?
Yes.
Bias, I think it's not on the screen completely.
Oh, sorry.
Thank you.
Apologize.
Yes, I do know what withhold information means.
Okay. In his possession, nor provide any false information. Do you understand what that means, sir?
Yes,
Okay, so you're not to provide any false information. You understand that clearly, right?
yes,
Okay. Mr. Bradley acknowledges that no law enforcement official has threatened him to cause him to provide the information. You see that?
yes,
Okay. No law enforcement official has made any promise to him to cause him to provide the information. You see that?
yes,
And C, that no law enforcement official has told him what to say. Do you see that?
yes,
Okay, I want you to pay close attention to section C, that no law enforcement official has told him what to say. Do you remember that from when you signed this?
yes,
Okay, and you remember that throughout your dealings with law enforcement and the prosecutors, right?
yes,
Okay? And other than to tell the truth in any interview or testimony he shall give. Now, paragraph 2. Subject to the conditions set forth in paragraph 3 and 4 below, in exchange for Mr. Bradley's cooperation as set forth in paragraph 1, and upon satisfaction of the district attorney that Mr. Bradley was not the individual who fired the weapon that killed Mr. Abreu and Mr. Furtado, or that he directed any individual to commit the act, the district attorney agrees not to prosecute Mr. Bradley for any crimes arising out of the actions related to July 16, 2012, shooting homicides of Daniel Abreu and Safiro Furtado in Boston, right? So, to this date, you haven't been charged with that?
correct,
Not by Mr. Hagan? No?
correct,
Not by anybody in Connecticut?
correct again.
And you said you bought it from a guy named Jamar, right?
I don't recall who I got the gun from.
Your testimony today, sir, you don't recall who you got the gun from?
I don't remember exactly who I got the gun from.
Okay. You have a moment, Judge.
You may.
Jamar, you know a guy named Jamar?
Yes, I do know a Jamar.
Okay. And his name is Jamar Duro?
The Jamar I know, I don't know his last name.
You don't know his last name? But you know him as Rock, right?
I do know a Jamar who they call Rock, correct.
Okay. Kind of goes by the same nickname you go by. Rock, right?
No, you may answer, and
False. I don't have a nickname.
Oh, you're Rocky.
There you go.
Okay. He's Rocky, you're Rocky. Right, Rocky?
Right.
Objection.
Okay.
what a question.
I'm directing counsel to the October 8th proffer by Mr. Bradley. Mr. Bradley, do you recall being asked the question? Okay, and the silver firearm, the silver revolver, page, line 20, page 36. The silver revolver you talked about, do you know where that came from originally? And you answered yes. Where? I got it from him. I got it for him, the firearm. Okay, where did you get it from? I got it from a friend of mine in Bristol. Question, okay, who is that? Answer, a friend of mine that we call Rock. His first name's Jamar. I don't know his last name.
If that's what it says there, that's what I said, and that's what I just.
See that it says that there, sir?
I believe you if you say it's there.
Okay, so when you testified to the jury, you didn't know where you got that gun from. That's not true, is it, sir?
I didn't just say to the jury, I don't know where. I said I don't recall.
Okay, that you didn't recall where you got that gun from. That was not correct, was it,
Yeah,
sir?
I don't.
The objection is sustained. Rephrase.
You didn't recall when you testified to these ladies and gentlemen moments ago where you got the gun from, right?
I just told the jury that I don't recall who I got the gun from.
Well, on October 8, 2013, when you needed to get that deal and you made that proffer,
Objection and needed to get the deal.
Put the question.
you did recall who you bought the gun from.
If that's what it says there, if that's what I said, then
So the answer to my question is yes, sir?
at the time, then yes, if that's what it says.
Okay. So contrary to what you said a moment ago, your memory doesn't get better with time, does it, sir?
I just said certain aspects of it.
Welcome back to
That-
Law News Network. We are doing a little blast from the past today and taking you back to some of the testimony in the Aaron Hernandez case. That was Alexander Bradley, who was the main witness against Aaron Hernandez. I know many of you have said in the chat rooms that you love Jose Baez, and his cross-examination of Alexander Bradley, it got better, I think, as time went on. Jonna, what do you think when you have a witness like this who's got his own issues and his own reasons for testifying, and you've got someone like Jose Baez who is really strong with cross-examination? Isn't that sort of a recipe for disaster for the prosecution?
It almost typically, almost always is. And the reason for that is these guys come with baggage, right? And what by baggage, I mean credibility issues.
Right.
And your credibility really is everything when you're testifying on the stand. And if you can hammer that home to a jury, like they don't have, in fact, jurors are instructed, if you think somebody's lying in one piece of their testimony, you can discount all of it. He could be on the stand for days, and if you thought he was lying in one portion of his testimony, then you can discount everything that he said. That's a powerful jury instruction. And I think most defense attorneys know that. And they go for the jugular in that sense when they're cross-examining a state's witness.
Yeah, absolutely. And Jose Baez is especially good at going for the jugular. I mean, he knows, he really, I think his cross-examination is some of the best out there that we watch on these cases. I also want to talk to you, and I want to play the next clip and then talk about, the relationship between Aaron Hernandez and Alexander Bradley. At the time we were talking about it and really wondering at it, because some of those text messages, they almost sounded like, they were very close, almost like this romance going on.
Right.
And we know that Aaron Hernandez has since committed suicide, and I'm wondering whether the fact that he was betrayed by a friend played any role in his, and we'll never know the answer to that question. But as we listen to the testimony where you've got one of your very best friends, if not your best friend, up on the stand and trying to put you away for life and really betraying you, the impact that must have had for Aaron Hernandez.
Great perspective.
Well, it's we'll never know the truth of it, but this case has been so tragic and such an interesting case in so many ways.
Is it more tragic? So do you think if you're Aaron Hernandez, who's now deceased, and your buddy is turning on you, but he's turning truthfully, is that more tragic in Aaron Hernandez's mind than if he was up there lying just to make sure that your friend got convicted? Like, I'm sure that there had to be some truth in Alexander Bradley's testimony.
Yeah, I think that there probably was as well, but the jury didn't seem to buy him.
No.
I think that there were other things they bought, but they didn't seem to buy him.
Yeah.
So we're going to continue to watch a little bit of Alexander Bradley's testimony, and then a little bit later we're going to talk about something called the Batson Challenge, which is a challenge that you can make in these cases when you feel as though a juror is being struck for their race or their sex or any of those particular factors. And we're going to talk about the interview that we had with Ronald Sullivan, who is Aaron Hernandez's attorney, after they got the defense verdict, and his relationship with Aaron, and the conversation that he had with the judge about those particular race factors in that case. So we're going to play a little bit more of Alexander Bradley's testimony, talk to Jonna a little bit more while we have her here, and then go into Ronald Sullivan's interview. In retrospect, looking back on it now, knowing that Aaron Hernandez has passed away, knowing that we've covered other cases in Massachusetts where the jury situation was handled a little bit differently, and we'll talk about that. But for now, more on Alexander Bradley.
Now, stopped at 6:17. At the time, did you know the individual here in the braids?
No.
Had you ever met him before in your life?
No.
You ever heard of him before in your life?
Never.
Any of the people we see with him, had you ever met any of them prior to that?
None.
Mr. Bradley, I've stopped at 6:51 of the video. Do you recognize the two people coming in here where I have the cursor?
Yes.
Who is that?
Myself and Mr. Hernandez.
And the gentleman who seems to be leading you or walking you in, did you know him?
Yeah, from going up there, he was usually there when we went. He was usually the guy that kind of took care of us.
I didn't hear that. He was kind of the guy who what?
He was usually the guy that took care of us. He usually escorted us down when we arrived.
Do you remember his name?
No.
Mr. Bradley, when you went downstairs into Club Cure, where did you and Mr. Hernandez go first?
We went to the bar.
Did you go to the bar together, meaning the same area of the bar, or did you go to separate parts of the bar?
We walked to the bar together, and then we went to separate sections of the bar, separate ends.
What do you mean by that?
Mr. Hernandez went off towards the right, and I went off towards the left side of the bar. It's different bartenders.
And why did you go to different bartenders, if you know?
I mean, those appeared to be the open spots. You know, I just go where I could get in and get a drink.
I'm showing you what's been entered as exhibit number 38. Do you recognize that, sir?
Yes,
And does that appear to be Club Cure, at least Club Cure after renovations?
yes,
But is the placement of the bar still the same as it was back in 2012?
repeat that, please.
Is the bar, at least the bar area here, the same as it was
yes.
in 2012?
Yes,
You indicated that you and Mr. Hernandez walked up to the bar. What side did he go to?
he went off towards the right.
Over here?
Yeah, towards that side, yes.
Where did you go?
Towards the left side.
Did you get a drink?
Yes, I did.
And did you see whether or not the defendant, Aaron Hernandez, got a drink?
Yes, he had got a drink or two.
A drink or two?
Yes,
And why do you think two?
because a lot of times when we drank, we would get a shot of something and then another mixed drink. So we have two drinks.
So was there a period here that we're talking about when you're getting your drink, he's getting his drink, where you two were apart?
Yes,
And did you ever see him go off with a fan to get a picture taken?
no, I don't recall him taking a picture with a fan.
But was there a time that you were apart that could have been when he got a picture with a fan?
Objection, Judge.
Sustained.
Well, how long were you guys apart when you went downstairs and got drinks?
Not very long. I guess as long as it would have taken for us to both get drinks on separate ends of the bar. I mean, I don't know.
After you got your drink, when was the next point you saw the defendant, Aaron Hernandez?
From
When did you see him? Did he come to you? Did you go to him? What happened next?
I just turned away from the bar after I got a drink, and I believe I turned and looked over, and we just kind of both met up somewhere in the middle over there near the bar.
And can you, that's a touch screen where you are, Mr. Bradley. Can you show where the two of you met up?
Somewhere in this area, right here.
Right there, we have the green dot. When you met up,
Yes.
did he have a drink or two?
Yes,
Did you have a drink?
yes.
Did you start to have a conversation of any type?
I believe just a casual conversation. I don't remember exactly about what, but just
As you were standing there, Mr. Bradley, with Mr. Hernandez, what happened next?
we were standing there, and there were some gentlemen off, not really too far from where we were standing, but more to the right.
More to the right side, this side over here?
Yes. And there was a group of guys, and one of the gentlemen was dancing, and he kind of danced his way over to where we were standing.
So he went in this direction here?
Yes.
And as he danced over to where you were standing, what happened next?
He bumped into Mr. Hernandez, and his drink splashed up and spilled on Mr. Hernandez, and some got on myself as well.
How much of the drink? A lot of it or a little? Or
No, just like a splash, more or less, I would say, like the drink splashed.
so it wasn't the whole drink didn't spill?
No,
And how much splashed?
just some drops, like, I mean, I don't know how to explain it, but a splash, like the drink splashed.
Did it get on your clothes or on Mr. Hernandez's clothes that you saw?
On Mr. Hernandez and a little bit on myself too.
Do you know what part of the clothing it got on?
Me, it was on my arm. I got splashed on my arm. I don't know, like, exactly where it was on Mr. Hernandez.
Did you see any stains on his pants or on his shirt or anything like that?
No, I just saw the whole drink splash thing. I saw the splash, but I didn't see, like, stains, no.
When the man bumped into him, was the man's back to Mr. Hernandez or was he facing
No,
him?
it was kind of like the side of his body. He bumped in, like, with the side, maybe the shoulder type of thing.
And what was he doing when he bumped him? Did he appear to be?
He danced his way over there, like, he bumped him in rhythm, like, he made it appear as though he bumped while he was dancing.
And the man who you saw bump him while dancing, have you seen him on the screen so far yet today?
Yes, it was, yes.
And who was that?
Gentleman, you asked me if I saw him earlier with the braids, if I ever saw him before.
And is that the individual I have the cursor on here, sir?
Yes.
When he bumped Mr. Hernandez, what was the reaction from both of them?
Mr. Hernandez was mad. He turned towards him. And, I mean, I'm not sure if he did get words out or whatever, but he turned towards the individual and he was upset about it.
What made you think he was upset? What did you notice about his demeanor?
Because he turned angrily. You know, like he turned. Like he turned in a manner in which he was going to make a confrontation out of the issue.
Did you say anything?
I don't remember him getting many words out, no. I don't remember him saying too much, but he turned.
What did the man with the braids do?
The individual with the braids was laughing. He smirked. He was kind of laughing at the whole situation. He was aware of...
Was he facing Mr. Hernandez at that point?
Yes.
And he smirked at him?
Yes, he laughed. He was aware of the fact that the bump just occurred. He knew what just happened, and he smirked about it.
What was Mr. Hernandez's reaction to the smirk?
Mr. Hernandez was upset about the incident, the fact that he bumped into him, and that the individual, you know, didn't show respect and apologize. He just bumped into him and laughed about it.
And where were you at this point?
On the other side of Mr. Hernandez, standing side by side with Mr. Hernandez.
You were on his side? Do you remember if you were on his right side or his left side?
I was on his far side. So the way we were facing, I was on the left side of the green dot from how the screen's facing me.
On the left side of the green dot?
Yes.
Now, did that man with the braids who bumped into Mr. Hernandez and then smiled at him, was he with anybody else that you could tell?
Yeah, there was another group of individuals still standing in the spot that he was before he danced his way over there. So
where was that spot, if you could estimate?
Not as far over as this purple, but the original one you made, but right around here somewhere.
How many people did you see with him?
I believe there was at least 4 individuals with him.
What did they look like?
Darker complected. They appeared to be, a couple of them appeared to be African American, and that's pretty much how they looked.
And the man with the braids, what was his skin tone and coloring?
He appeared to be Hispanic, light skin, sort of like myself.
And any of the others in the group, did they appear to be light-skinned, or were the rest dark-skinned, if you recall?
There was some brown skin, and I think I recall one dark-skinned guy. And yeah, that was that. I think they appeared to be darker skinned.
Did they appear to be part of, well, let me back up a little bit. When the bump happens, and you said Mr. Hernandez turned to the individual smiled, was that man with the braids with anybody else, meaning was anybody else right next to him, or were they further apart?
Excuse me. They were closer to the original spot he was prior to bumping into us, but they weren't far. All of this is in close proximity. They weren't that far.
What happens after what you've described, where Mr. Hernandez got angry? What happened next?
Once Mr. Hernandez turned towards the individual, I kind of grabbed him by he had a short sleeve tee. I kind of touched him on his collar and was like, nah, let's just get out of here, you know, to avoid the conflict.
Why did you do that?
Because I knew something was brewing. If I didn't do that, we were going to have an issue in there.
What would make you think that?
Because his temper, the way he was just agitated, and I just knew what would happen.
Now, Mr. Bradley, in the prior occasions, the 2 instances you talked about at venue and in Manchester, you indicated those times you stayed in the club. Is that right?
Right.
But this time you wanted to leave?
Yes.
Why was that?
Because I didn't want conflict. I didn't come up there for that, and just to avoid it. Plus, he was in a position in his life where, you know, he didn't really need that. So I just figured we could get out of there. There's other spots around.
What did you say to him?
I said, no, come on, let's get out of here. You know, don't worry about it. It's nothing.
Did the man with the braids say anything to Mr. Hernandez?
I'm not exactly sure. I don't believe he did, but he was standing there laughing, kind of laughing about the thing, about the situation.
If you could estimate, how long did this encounter take?
Sure, it was real quick. Maybe the whole thing, maybe a minute, the whole encounter.
And at that point, you said you told Mr. Hernandez you should leave the club. Is that right?
Yeah, that we should leave. Yeah.
Did you ever hear Mr. Hernandez say anything to the man with the braids before he left?
No, I don't believe he got real words out because I was already on top of it fast.
But did you hear any words that he got out?
Maybe one swear, like, I'm not positive. I think he was starting to say something, and then I don't recall exactly what he said.
What happened once you started to walk away? Did you leave the club?
Yes, we left.
As you went up the stairs of the club, was there any conversation further about what had just happened?
Coming up the stairs?
Coming up the stairs,
I don't
yes.
recall what the exact conversation was. I just, we were just trying to get out of there. We were getting out of there.
Now, I fast forwarded the exhibit to 8 minutes and 20 seconds. Is that you there, sir?
Yes,
And the person here?
it's Mr. Hernandez.
What is he doing in the video, if you know?
Just finished up 2 drinks. Well, looks like 2 drinks. And I could see a phone in his hand, and then that's it. We just left.
Do you have any idea what he was doing with the phone?
None. I looked both ways, went through the light, made sure there was no traffic coming.
Was the light red?
Yes, the light was red.
Why did you go through the light?
Mr. Hernandez was telling me to go.
What did he say exactly?
He was saying, he said, go, to catch up to the car, the BMW that passed.
Did you go through the light?
Yes,
What was your intention at that point?
to pull up to the car.
What, if any, observations did you make prior to that point regarding the glove box?
After I got through that light, as I was approaching the car, he removed the firearm from the glove box.
He being who?
Mr. Hernandez.
What did you think was going to happen, Mr. Brown?
I thought at the very most, he might try to intimidate him or, maybe say something or address the issue that happened previously at the club.
Did you have any idea he was going to do anything more than that?
No.
Did he state anything about what his intentions were?
No.
After he said go and you went through the red light and observed the gun being taken out, what happened next?
As I was approaching, there was another light after that. I believe that car was at a red light. I believe the light was red. And as I was approaching the car, he told me, watch out. He was telling me, roll the window down first is what he said. Roll the window down. And I rolled the window down. And when we got up to the car, like right when we were approaching, he put his hand on my chest and was like, watch out, like indicating for me to, like pushing me back kind of in the seat, like so I could lean back.
Did you lean back?
Yes, I did.
How did you do that?
With the button on the side, I reclined the seat.
What happened next?
I rolled the window down, reclined the seat, and he leaned across me and extended his body out the window with the firearm in his hand.
And when you say extended his body out the window, was his whole body out of the window or just a part of his body?
Not his whole body. He extended from where he was sitting in the car across me, across where I'm sitting, onto my side. He was bracing himself, off the, I want to say, somewhere on the floorboard, maybe near. He planted his feet over on his side and leaned across me, extended across my body.
And what about his hands? Where were his hands positioned?
He wound up placing his hand in the area of the armrest, I believe on the armrest.
And for the record, you're taking your left hand and placing it to your left?
Yeah, well, the armrest would be to his left, correct.
And what hand was he holding the gun in?
His right hand.
What did he do with that arm and hand?
He stuck it out the window. He fully extended across.
Where was the car in relation to the BMW at this point?
The car was side by side, real close.
What, if anything, did you observe about the inside of the car, the BMW?
I remember a gentleman, I remember all of them, at least the 2 front ones with their head down. A gentleman was holding a phone in his hand, and that was it.
What did Mr. Hernandez do or say?
He said, yo, one time, and the gentleman didn't respond. Like, nobody turned around from the car. They weren't aware of the fact that we had pulled up right on the side.
How loudly did he say, yo?
He was like loud enough trying to get their attention.
After he said, yo, what happened next?
He wound up saying, yo, again. And then they turned, and then he started firing rounds into their vehicle.
Did he say something before he fired?
Before he fired the gun, he was like, what's up now, niggas? And he started firing shots.
Welcome back to Law News Network, where we're playing some greatest hits from the Aaron Hernandez trial. That's Alexander Bradley going back and forth with both the prosecutor and the defense attorney, Jose Baez, and trying to explain some of the events of that evening. Jonna, you know, he really held his own to some degree over, I think, 3 full days of testimony. What do you do when you're cross-examining someone who you can't shake, despite the fact that you know you have information that is contradictory to what he's testifying to?
You call up opposing counsel and find out who they hired as a coach, because he did a really good job.
Right.
Yeah, he seemed pretty unflappable, and here's an interesting little tidbit, because this comes up a lot in real life. He was pretty unflappable, which means he obviously did talk to, say, prosecutors. Now, prosecutors do not represent their witnesses. There is no attorney-client privilege there. So it would have been fair game, and it is fair game for defense attorneys to say, who did you talk to in preparation of your testimony? What did they say to you? Who did you sit with? Because if it's not your own personal attorney, there is no privilege.
Right.
He must have spoken with, for lack of a better word, a coach. They
Right.
must have really went through what he was going to be asked and how he should, what his affect should be.
Yeah, and Alexander Bradley, I think, was pretty invested. I think he was, I mean, listen, Aaron Hernandez shot him in the eye.
Yeah.
I think, and in the groin. I mean, 2 areas that nobody wants to be shot in.
No.
So I think that he really wanted to do well and was ready to take on Baez. And I think Baez, especially the first day of cross-exam, got frustrated with him. And I think sometimes you're just not going to get that grand slam answer.
Most times you're not going to get that. You're not going to have that Perry Mason moment.
That's
People
right.
aren't going to be pounding their fists on the table. It's real life.
Yeah, it's not going to be like A Few Good Men where he's like, "You're goddamn right, I
You
did."
can't handle
right.
the truth.
Yeah, it's going to be a whole lot different than that.
Yeah.
But it's you've got to just bit by bit, piece by piece, take
just it.
apart a witness, and then in closings, string all of those pearls together in order to make your necklace. And I think that that's what Baez did very well here. And then I think his closing was phenomenal in sort of setting up, you know, all of the facts, and he made the jurors laugh, and he really got into all of the little details about Bradley's testimony that were inconsistent with the evidence.
Yeah.
Now, I want to give you some programming notes, guys. We are still waiting for the Adrian Loya case to begin. We know that the jury is just about chosen. They still have a little bit more of jury selection to do. And then we hope to hear opening sometime early afternoon today on this new case that's going to be fascinating. We're going to hear a little bit about the insanity defense. We're going to hear about from expert witnesses in that regard, and that should start shortly. I know some of you are also looking right now at the Sidney Moore obstruction of justice case. That's also available on our site, and you're able to get that at LawNewz.com. But stick with us too as we continue to go through some of the things from the Aaron Hernandez case. We have the interview with Ronald Sullivan coming up a little bit later. That is the interview where he spoke about the defense verdict. He spoke about his argument with the judge in that case, and that argument got a little bit heated. We're going to play that little bit of the argument before we listen to that interview. And then he also spoke about Aaron Hernandez's plans going forward, and those plans, as we know, came to naught after Aaron Hernandez killed himself. So it's a really interesting interview, given what we now know that was not even an iota of an idea at the time of the interview. But for now, we're going to continue to play Alexander Bradley's testimony and look at the various ways that he was able to make points against Baez, and Baez was able to make some points against him. So stay tuned for a little bit more of that.
To go shoot some people or scare them.
Not correct. There you go.
Okay.
There you go.
And you're okay with that.
I was okay with the thought that he
And
was.
you're also okay with lowering the seat back.
Let the witness finish his answer, please.
You're also okay with
Hold
lowering
on.
the seat back, right?
Mr. Baez, hold on.
As I,
Finish your last answer.
no, as I was saying, Mr. Baez, I was okay because I never expected Mr. Hernandez to shoot those individuals.
Of course. Now, you're okay now with lowering your seat back too, right?
After he told me, watch out, yes.
Okay. And you testified that when he said, there they go, you didn't say anything there, right?
He said, there they go, let's go.
And you didn't say to Aaron, there who goes?
He was already walking towards the car.
No, my question to you, sir, is you didn't ask him, there who goes?
No, I didn't.
You hadn't seen these guys in over 2 hours.
Correct.
Okay? So after not seeing some guys for 2 hours, that thing is out looking for girls, that thing is completely out of your mind. You're just following orders, right?
I'm leaving with my friend. If he's saying let's go, whose car belongs to him. If he's saying let's go and he's going towards the car and it's his car and I'm down there in his car 60 plus miles from home, yes.
The car which you've driven many times on your own, right?
Depends on what you would define many, but I've driven it, yes.
Okay. And times you've borrowed that car many times too, right?
I wouldn't say many,
You
no.
borrowed that car. And
I,
after the shooting,
I have driven the car.
and even after the shooting, you've driven the car, right?
Wrong.
Okay, we'll clear that up in a minute. I don't want to bounce to too many areas. But, so now, so yesterday, or I'm sorry, the day before yesterday, you said that Aaron Hernandez had shot the gun 5 times, right?
Correct.
And when you were quite clear about that, right?
Correct.
Okay. And this is something that you just have in your memory, hearing 5 shots, right?
Correct.
And in fact, you were able to distinguish the difference between 5 shots and 6 shots, right?
Correct.
Okay, because you said 5 shots, right?
I believe at one point I said 5 or 6 and 5 as well.
I know you know where I'm going, but my question to you, sir, is at some
Put
point,
a question to the witness without commentary,
when you
please.
testified to the jury, you told them 5 shots, right?
Yes, I recall saying 5 or 6 shots as in a testimony as well. So
I'll repeat the question because I don't think you're understanding. When you testified to the jury, you said 5 shots.
to the jury, I believe so.
You believe so?
Yes, I believe so.
Okay. You were unequivocal. You said absolutely. You said 5. You didn't say 5 or 6, right?
I said 5, correct.
All right. Now, the first day that you spoke with law enforcement and you gave your proffer under that letter, do you recall being asked, how many shots do you think were fired? And you answered, oh, that gun has 6 bullets. So he had to fire every bullet in there. Did you hear? The next question. How many did you hear? Answer, 6, probably 6, about 6. Question, okay. Do you remember that?
I believe I said that gun holds 6 shots.
No, your exact words was, oh, that gun has 6 bullets, right?
If those are my exact words, then yes.
Okay, let me show you them so we don't get,
That'd be better. Thank you.
may I put us witness?
You may.
I'm showing you your statement of October 8th proffer that was based on the proffer letter for which you were ultimately granted immunity. There's your answer highlighted in line 20 and 21.
Yes, those are my words. Accurate.
Okay. And accurate means, oh, that gun has 6 bullets, right?
Correct.
So we had to fire every bullet in there, right? You said that?
Correct. Those are my words.
Now, you also said that after the gun was fired, you heard the clicking sound, meaning the trigger was pulled multiple times after, right?
Correct.
And you're aware that the .357 Magnum that you bought had 6 bullets, right?
No, I don't believe that I know definitely it has 6 bullets in
But
it.
yet you made the statement, oh, that gun has 6 bullets.
It's probably,
Now, you testified that your phone died and you wanted to charge it in the VIP room at Tootsie's?
yes, I was trying to find the charger for my phone, correct.
Okay. And then it got left behind at Tootsie's?
Yes, at some point.
Okay. Okay, Miss Medina just found text number 9. That's been admitted into evidence in the composite of the text messages.
Okay.
Apologize, I don't have the exhibit number, but I'll supplement the record. Do you see the number 860-726-3749?
Correct.
And that's to Aaron's number, the 203 number, right?
Yes.
Okay. And this is where you talk about if I dealt with the police, my boy, this would have been over.
Correct.
And you're right, you're too paranoid, that's what made you do this. You remember that?
Correct.
Okay. So now you agree that that was your number 2?
3 weeks later, yes.
Okay. 3 weeks later, not in Florida, right?
No, not in Florida.
That's what you want the jury to know?
Objection. Sustained as to the form.
Okay. May I approach the witness?
You may.
I'm showing you now from Exhibit 249E, Aaron's phone records. May I approach the witness? Can you read this phone number that I have highlighted here?
726-3749.
Okay, that's your phone number, right?
Yes, on February 12th.
That's the day before you got shot,
Correct.
not 2 weeks later, like you just testified.
Correct.
Okay, so that, in fact, you did have that phone number,
Yes, I did have that phone number.
okay? And then, can you read this phone number here to the ladies and gentlemen of the jury?
860-706-4709.
That's another phone number, right?
Correct.
Okay, and the date that is?
That's on February 13th
At what time?
at 7:54 a.m.
Okay, so those are 2 numbers, right?
Correct.
You had both those numbers at the time on your Florida trip?
Yes,
Are you asking if he had them with him or if they were assigned to phones he
Assigned to him. You had both of those numbers assigned to you on that trip, correct, sir?
yes, I did.
Okay. So you didn't get one 2 weeks later like you just mentioned.
I didn't say I got it 2 weeks later. I said 3 weeks later, meaning that's the date you're showing me the number again.
Okay. 3 weeks later.
Correct.
So you had both of these numbers assigned under your name at that time, right?
Yes, I had 2 numbers. Correct.
Okay. Yeah, 2 phones.
Correct.
Okay. Now, told the ladies and gentlemen of the jury, well, I'm going to backtrack. The police asked you if you had a phone with you that day, right?
You mean the day that I was shot?
Yeah.
I believe they did.
That's the only time you were talking to the police, right? The day you got shot?
Objection.
February 13th?
No, you may answer that.
They may or may have asked me about a phone.
Do you have any other interactions with the police on your trip to Florida?
Yes, leaving to get my property from the department and the interview from my hospital bed.
Prior to getting shot? Did you have any interactions with the police?
No.
Do you remember telling the ladies and gentlemen of the jury that, well, you just mentioned you left your phone at Tootsie's, right?
Yes, I believe I left my phone at Tootsie's.
And then you told the police you didn't have a phone, right?
Correct, because I didn't have a phone.
Because you left it at Tootsie's, right?
I believe I left it at Tootsie's, yes.
Okay. May I approach? Can you read? Actually, I'll do it on the screen. Can you read this phone number, sir?
Yes, sir. 860-726-3749.
That's your phone number.
Correct.
And it's the originating number, right?
Correct.
Okay. And it is calling what number?
203-606-8969.
And what's the date and time that you made this phone call, sir?
I didn't make that.
Well, this phone call was made.
7:15 p.m. on February 13th.
That's the day you got shot, right?
Correct.
You got shot early in the morning, right?
Correct.
Okay. And it's your contention that you didn't make that phone call?
I can tell you exactly who made the phone call, if you'd like.
And from your lost phone?
That 726 number wasn't lost. It was left in Connecticut with a friend of mine.
That was there, correct? You left that in Connecticut?
Yes.
Okay. Do you see this call on the 12th, the day before at 9:40? Oh, sorry, it's blurry.
Yes.
Do you see that number?
Yes.
Okay. And do you see the numbers being called?
Yes.
Okay. You see the dates?
Yes.
These are interactions between you and Aaron, correct?
No, it's not an interaction between me and Aaron.
So those phone numbers are calling each other while you're in Florida. Is that correct?
That is correct. That phone is being called to Aaron's, and that phone's in Connecticut at the time.
And according to you, the phone's in Connecticut.
Yes, and I can tell you who had it, if you'd like to know.
Well, I'm sure we can clear that up. But it's not lost at Tootsie's, right?
What's not lost? That particular number?
The phone call that's making that call that night.
The 726 number?
Correct.
No, that's not lost at Tootsie's.
Okay. And you talked about how you have two phones and you burn them, right?
One's a burner phone, yes.
Okay. And you're always changing phones every 30 days.
Sometimes more frequent than that, correct. Sometimes a little longer.
Okay. And basically you throw them away.
I don't necessarily throw them away.
You don't renew their minutes.
At a point, I usually don't, or I either pass it to someone else.
Because that's not good for a drug dealer to do, right?
Objection.
Overruled.
No, it wouldn't be good to do if you were selling drugs like I was.
Okay. And that's why you changed numbers. But yet, you wanted to get into a fight in the car, according to you, over this phone for which you were probably going to dump anyway, right?
Objection to get in a fight.
Rephrase, please.
I'll withdraw the question. Now, sir, you mentioned...
All right, everybody, welcome back to Law News Network. I'm Heather Hansen here with Jonna Spilbor, and we have for the past few hours been looking at some of Alexander Bradley's testimony. Jonna, do you think in total it was his testimony that was the death knell for the prosecution?
You know, no, and here's why. You got to remember this case. There really were no solid witnesses at all. There was not a whole lot of dots to string together. There was it was a difficult case to prosecute no matter what. Prosecution took a shot. It didn't work. Aaron Hernandez was already serving time for another murder. So I don't think the prosecution lost based on this one or any one witness.
I agree with you, but I do think they would have been better served by prosecuting both of them. Both Alexander Bradley and Aaron Hernandez.
Definitely.
Yeah.
Oh
Yeah.
my, yes. See, that's where they should have hired you. No, I'm serious, but you're absolutely right, because then they're doing this. They're pointing the fingers at each other instead of one person who's getting a deal pointing at another person who's already in prison.
That's right. What we're going to do next, well, first I want to thank Jonna for being here with me this morning and
Thank
going
you.
over hurricanes and interpreters and insanity and Aaron
Covered it all.
Hernandez, and you got it all in your short 2 hours here. So I want to thank you so much because it was fabulous. What we're going to do now